I heard you coming.
Yeah, you heard me coming. I knew it.
Okay, well, good morning, everybody. It's Thursday morning, February 23rd, and this is the Ag Committee holding their morning meetings. And this morning, we're going to be working on draft 230138, nuisance right to farm bill. And we have a group of people that we're going to be taking testimony from. And we have, well, we'll introduce ourselves first, and then we'll get started.
Brian Collmore, representing the Rutland District.
We have Irene Winter, and she's going to be on Zoom this morning.
Brian Campion, Bennington County.
Rich Westman, the Lamoille District.
And Bobby Starr from Orleans District. We'll get started with Scott this morning from CLF. Good morning, Scott, and welcome to the committee. And hopefully you've been seeing the updates that we've made to the bill up to this point. And so we'd be glad to hear your take on the updates and anything else that you'd like to chat with us about in regards to the bill.
Absolutely. Well, thank you very much. Yeah. So good morning, Chair Starr, members of the committee. For the record, my name is Scott Sanderson, and I'm the manager of Farm and Food at Conservation Law Foundation. I'm an attorney, and I coordinate advocacy and services that help our food system steward the environment, create opportunity. Oh, are you, am I coming through?
Yeah, you're okay.
You're okay.
We needed to turn our volume up a little bit.
Oh, okay.
Here we go.
Yeah.
Thank you.
Go.
Perfect. Okay, cool. So, as I was saying, I'm an attorney and I coordinate advocacy and services that help our food system steward the environment, create opportunities for farmers and food professionals, and provide everyone access to healthy, local, affordable food. One part of my job is looking after the Legal Food Hub, which is a unique service that connects New England's income-eligible farmers and food professionals with free legal assistance. And I believe that farming and a farm sector that is innovative and thriving is crucial to Vermont's well-being. So thank you for offering me the opportunity to testify on the most recent draft bill, which I believe is draft 2.3. I also submitted written testimony, and I'll touch on the main points here. So my main focus is going to be on the generally accepted agricultural practices standard and the mediation requirement that draft 2.3 add, since those seem to be the main changes to the bill. But I do want to emphasize that the draft bill, it prompts the same concerns for me that I expressed in my testimony several weeks ago. I continue to think that draft 2.3 limits property rights, limits the use of the courts when Vermonters have no other option to protect their property, health, and welfare, and upsets the careful balance that Vermont's existing right to farm law establishes. The new concerns that I think draft 2.3 raises, there are a couple of those. I believe that the generally accepted agricultural practices standard further limits property rights, primarily by focusing on industry custom rather than on injury. That the mediation requirement is unlikely to succeed within the context of this bill, and that the draft introduces several factual issues that I think are likely to complicate court proceedings. And for those reasons, I continue to think that the best path forward is really just to preserve Vermont's existing right to farm law. So I'll just begin here by touching briefly on 4 ongoing concerns that I have. So the first one is that I think draft 2.3 limits property rights by extending right to farm to include trespass. And as I noted during my previous testimony, the law of trespass protects the right to exclusive possession of property. Under certain circumstances, this draft would protect a farm that causes a trespass on a neighbor's property without the neighbor's permission. And by doing so, I think it facilitates situations that jeopardize property rights, and it denies neighbors who find themselves confronted by those situations the legal tools that they would need to respond. So second, by abandoning the existing right to farm law's rebuttable presumption, I think the draft limits Vermonters' options when their property, health, and welfare are threatened. The current right to farm law offers qualifying farms extra protection from nuisance lawsuits, an extra protection that a neighbor can only overcome if they're suffering from a particularly severe harm. And I think this balanced approach protects farms from unfair lawsuits, but also gives neighbors an option of last resort in particularly difficult circumstances. Now, by contrast, I think draft 2.3 offers qualifying farms complete protection from nuisance and trespass lawsuits, whether or not the farm is causing an injury. And it doesn't really matter under draft 2.3 whether the neighbor can bring evidence of severe harm. The neighbor's ability to protect themselves and their property through the law of nuisance and trespass simply gets cut off. And I don't think that's the best way forward. Third, draft 2.3's 1-year statutory deadline, it continues to strike me as too short to provide Vermonters meaningful use of the court. Now, the committee heard testimony just yesterday from a farmer who explained that he was reluctant to litigate over a nuisance caused by his neighbor, who's also a farmer. He'd rather try other options first. Now, all the same, he worried that draft 2.3 could take away his tool of last resort because it only gives him a year to file. And I think his case illustrates the challenges that a short 1-year deadline creates. And then the last of my ongoing concerns here is that I continue to think that the draft relies too heavily on the assumption that ANR and AAFM will protect Vermonters by promptly implementing the state's regulations. And again, yesterday, I think the same farmer explained that AAFM needed 1 year to conclude that it had no jurisdiction over the farm causing the nuisance. And it strikes me that 1 year is just a very long time to allow a harm to continue, only to conclude that there's really nothing that you can do. So those are sort of the ongoing concerns that I have. And now I'd like to turn to draft 2.3's new components and the concerns that those raise for me. So in my opinion, the draft's generally accepted agricultural practices standard weakens landowner rights by using industry custom rather than the injury suffered by a neighbor to determine whether an otherwise unregulated agricultural activity is causing a nuisance or a trespass. So under the draft, an activity that is conducted in accordance with generally accepted agricultural practices is neither a nuisance or a trespass. And under my interpretation, whether an unregulated agricultural activity meets this standard essentially boils down to whether the activity is common on similar farms. If the activity is common, then it causes neither a nuisance nor a trespass. In my opinion, this standard ignores that a common agricultural activity might cause substantial injury if it's implemented in the wrong circumstances. And I think that the Erie Point case illustrates exactly this. Now, the primary injury in Erie Point was damage caused by the discharge of agricultural waste from tile drains. Farms, of course, often install tile drains to improve farmland's productivity, and usually those tile drains don't directly harm neighbors. However, in Erie Point, the newly installed tile drains caused increasing quantities of wastewater that contained E. coli at levels higher than Vermont standards to overrun the neighbor's land, damage their property, and flood fields that the neighbors use to rotationally graze cows, sheep, and chickens. Now, nuisance and trespass, of course, are meant to protect neighbors from harm. Whether an agricultural activity causes harm doesn't always depend on whether it's common or not. It often just depends on how that activity is implemented in the circumstances. And I think draft 2.3's generally accepted agricultural practices standard doesn't quite account for this, and it consequently exposes Vermonters to unnecessary risk. So turning to the mediation requirement, I think the requirement is unlikely to resolve disputes between farmers and landowners because it doesn't extend or pause the draft's 1 year statutory deadline to accommodate the mediation. So instead of clearly pausing the deadline upon a landowner's decision to pursue mediation, the draft seems to allow the clock to run as mediation proceeds. And this creates the possibility that the deadline will pass before mediation concludes, denying the landowner the right to pursue a nuisance or trespass lawsuit, even if mediation is unsuccessful. Moreover, I think this could give farms an incentive to treat mediation as an opportunity for delay rather than as an opportunity to identify a mutually agreeable resolution. And then I guess my last point here is that I think that draft 2.3's mediation requirement and its generally accepted agricultural practices standard are likely to complicate court proceedings by adding fact-intensive issues to already fact-intensive nuisance and trespass lawsuits. So draft 2.3 requires the court to answer two questions that draft 2.2 didn't require the court to answer. The first one is whether a landowner and the farmer at least once attempted through mediation to solve the issue or dispute raised by the landowner. And the second question is, did the farmer conduct the agricultural activity in accordance with generally accepted agricultural practices? So the question raised by the mediation requirement is both factual and a little bit ambiguous. It's factual because the neighbor and farmer must bring evidence to prove that mediation was or was not attempted. And it's a little bit ambiguous because it's not entirely clear what a landowner and a farmer must do to attempt mediation, whether or not one day of mediation is enough. You know, at what point have you concluded or satisfied that requirement? Second, the draft's generally accepted agricultural practices standard, that strikes me as much more complicated. It requires a landowner and farmer to bring evidence establishing whether the agricultural activity meets agricultural water quality regulations, whether it conforms to pesticide regulations, and whether it reflects industry custom. And that last element, whether the agricultural activity reflects industry custom, that strikes me as raising yet another battery of issues that the landowner and farm will likely dispute. So which farms the court should treat as similar operators of agricultural activities, what circumstances the court should treat as similar circumstances, what area the court should treat as a similar municipality or region of the state, and what proper and accepted customs or standards are established by a thorough review of all those similar operators, right? Those are all different points that the litigants are going to need to dispute. So I know that AAFM testified on January 18th that it felt that one of the existing right to farm law's shortcomings is that it raises too many factual questions. And in my opinion, between the generally accepted agricultural practices standard and the mediation requirement, I think draft 2.3 is beginning to raise just as many questions, if not more. So to wrap this up, I think that Vermont's farms face a very long list of challenges, from production costs that exceed prices, unfair federal programs, challenging access to markets, accelerating farm consolidation, rising fees and surcharges, rising land prices. There's a lot more. I just don't think that nuisance and trespass lawsuits make the list of key problems threatening Vermont's farm and farm economy. I don't think that there's really a problem here for draft 2.3 to solve. And given that draft 2.3, in my opinion, has a tendency to limit property rights, to limit recourse to the courts, and to complicate court proceedings, I think that the most promising path forward is simply to set aside draft 2.3 and to preserve Vermont's existing right to farm law. I think it's a good law, and I think that it's already doing its job. So, thank you again for inviting me to testify. And of course, I'd be happy to answer any questions that you have.
Yeah, you mentioned several times, Scott, generally accepted ag practices, and what we've been talking about is required ag practices, and there is a difference between generally accepted ag practices and required ag practices that we're running under the assumption that if a small, medium, or large farmer, if they apply for their permit, which they have to do, they're required ag practices that they have to follow and not generally accepted ag practices. Did you take that into account when you were looking at the two, and one's required and the other's generally accepted?
Yeah, so the draft that I have, the draft 2.3 that I have, it says that generally accepted agricultural practices mean an agricultural practice that meets 6 VSA Chapter 215, including the permitting requirements of the required agricultural practices, the requirements of the pesticides regulation, and then also is conducted in a manner consistent with proper and accepted customs. And so I suppose the point that I'm trying to make is that if an activity doesn't fall under a set of regulations, the way that the draft bill sort of fills that space is by looking at similar farms under similar circumstances and asking what they do. So, there might be an activity, I can't think of an exact example right now where we don't have a regulation directly on the books for that. The place filler would be to look at a similar farm. And I think that in that case, looking at similar farms is not a good way to fill the space. I think when there isn't a regulation to fill this, to indicate how a practice should be conducted or something along those lines, it's much better to follow the existing right to farm laws structure and focus on the harm that the practice might be causing under the circumstances, rather than taking the practice out of context, looking at what other farms do, and then trying to compare that way.
Michael, I have a comment.
The bill as introduced had the 1-year standard in compliance with the RAPs. But then you heard testimony from the agency about compliance, pesticide rules being something that you wanted to work in as a standard. And then you asked how other states address the issue. And other states do have the custom and practice in the neighboring area as a standard, because the concept is if it's such a common activity in that industry, it likely is not creating an impact on the use and enjoyment of neighboring properties. But I mean, it is a factual determination, and I said that the last time I was in.
Yeah.
It does reinsert a factual review by the court about what is common and custom in that area. I agree with Scott's point on that.
Brian?
Thanks, Mr. Chair. I think the part that I'm trying to pull apart and understand, Scott, is, and the hardest part for me on this bill is where you're saying it limits property rights and limits rights to the courts of Vermonters. And that really concerns me. Could you just say a little bit more about how that happens?
Right. And so
how this bill does that? Because, yeah.
Absolutely. So in my last testimony, what I described both nuisance and trespass and what they protect. And of course, nuisance protects your right to use and enjoy your property free from substantial and unreasonable interference. And then trespass protects your right to exclusive possession of your property. And so, as I understand it, both of those are property rights. And what a right to farm law effectively does is it protects farmers from lawsuits that would, and usually, under an ideal situation, it would protect a farmer from an unfair lawsuit that is trying to protect those property rights. So nuisance protects, again, use and enjoyment, trespass, exclusive possession. And so if a right to farm law goes too far, as I think this bill does, what it does is it would protect farmers who are violating those property rights, and make it impossible for a landowner to use the law of nuisance and the law of trespass to go to the courts and ask the courts to effectively reinstate those rights by asking the farmer not to interfere with them. And so that's how I see it interfering with property rights.
Got a follow-up?
Well, I just want to, Mr. O'Grady, would you disagree with that? I just want to understand, is this a point where most lawyers would say, there's points to disagree, or would most lawyers say, yeah, we're limiting property rights and the rights to court of Vermonters?
So whether or not property rights are limited is factual. For example, if you're trying to argue that it results in a takings claim, you have to go through a significant factual analysis. starting with whether or not, the farm's in possession of the neighboring land, and then it ends in a balancing test. And it's really difficult to say if the taking occurred without all of that. Is it possible? It's possible. There have been precedent in other states that laws like this somehow violated constitutional rights to inalienable possession of property. That precedent has been discounted because there are remedies here. A person can still bring a negligence. A person can still argue that the farm is not complying with the RAPs or the pesticide rules or the generally accepted agricultural practices as a whole. There is still a remedy. So there is still.
So we're not diminishing rights in any way, you think?
There's still opportunity to access the court, but you have to access it according to the conditions that are set forth in the bill.
And I'm just trying to get a sense, because I know we're going to get past this over and over again. Are we limiting? Is there an unbalance now here because of the bill? You know what I'm trying to, because everybody's going to ask us on the floor.
That is actually in the purpose section of the right to farm. The purpose section of the right to farm is to protect farmers.
The farmer,
from
okay.
Nuisance suits.
Okay.
That is
So that's-
the purpose of the chapter.
I just want to make
since it
sure.
was enacted.
Okay.
And as relating to trespass claims, yes, trespasses relates to your exclusive use or possession of property, but you also need to show a harm. So that is a factual issue that's still, that Scott didn't necessarily address, but it doesn't. Trespass probably is going to be very limited here, but you may not have had a trespass claim to begin with if you did not have an injury.
So
Okay, that's helpful.
Scott, did you have any comments on that last comments?
Yeah, just one thing to note, I think would be that while I think that the bill does provide other options to a landowner, such as negligence, which Attorney O'Grady brought up. I think negligence is it's a very different cause of action. Negligence is not specifically designed to vindicate a property right in the way that nuisance or trespass is. It's quite a different claim that is, in my understanding is based on a duty of care and whether or not a party violates a duty of care. And so I think it takes us away from the bill would take us away from those property claims that are meant to protect property rights and push us into an entirely different class of claims that are not tailored specifically to protect property rights.
And in your mind, Scott, what type of a trespass would the neighboring property owner lose if we move forward with our bill? Some example of how the neighbor would be not able to defend themselves.
Sure. So, I think that the Erie Point case is a good example of this. Like I said, the primary harm there had to do with ag waste being discharged from tile drains. And my understanding, looking through the various regulations that pertain to tile drains, most of those regulations have to do with how fields that are tile drained are managed, not with how the outflows are managed. And so for two reasons, I think that we'd have a little bit of a worry with the current bill. The first would be that the harm in the Vorsterveld case, in that Erie Point case, that developed over, I think, around 5 years. So the 1 year statutory deadline, that might create a trespass problem there that a neighbor could not deal with. And then the second part is that the way that those tile drains were installed, if you read the bill as saying, okay, look to the regulations that directly regulate the practice in question, the way that those tile drains were installed seemed to comply with those regulations. And so I think that would create an issue with trespass as well under the second condition that under the generally accepted agricultural practices condition. So I think that's a decent example there.
Are there other questions for Scott? Anything else, Scott, from your point of view?
No, I think that's all.
Yeah, no other questions?
Can you stick around while we continue, or are you done?
Oh, absolutely. Yeah.
Okay.
Yeah, thank you.
Thank you.
Scott.
Thanks very much.
So, Brian?
Yeah, I just trying to understand. I thought the case that was referenced, the court decided that for the plaintiff, based on the RAPs not being followed, but was that not how it eventuated?
So my understanding, oh, I'm sorry.
That's fine.
Go ahead.
I think the court had several holdings. One of which is that there was a trespass from the tile drains, the increased drainage from the tile drainage across that land, and it did cause an injury to the neighboring property owner. So there was a trespass. And then the court said, if the right to farm was going to be asserted, that judge did not believe that the right to farm conditions had been met. First, that it was unclear whether they had complied with the RAPs. The farm had argued that they had no enforcement by the agency for violation of the RAPs. And the court responded that lack of enforcement does not mean compliance. In addition, the farm had settled some environmental violations with DEC. And then the court went on to say that it was likely that the plaintiffs could have overcome the bar on nuisance by showing that substantial interference to use and enjoyment, that they could have overcome the presumption. So there were several factual determinations that the court made and legal determinations that the farm did not qualify for the right to farm, and even if it did, there was a trespass. And the right to farm, or current right to farm, does not protect against trespass.
So, Michael, how does we didn't even talk about when we put this together, that case that went on in Addison County and trying to, avoid. We didn't want to get mixed up in that when we were putting this together. We just felt as a committee that after 25 years of being in place, that the law had to be updated to meet today's farm community because of the loss of so many farms in the state in the last 25 years. Neighbors are getting closer in new housing. Neighbors are getting closer to farms all the time. And so how would you characterize our draft proposal compared to what's on the books today? Do you see it limiting the neighbors a lot more than the previous law does?
Well, I just want to go back to the purpose of the right to farm in the statute, and it's been the purpose since enactment, is to protect farms from nuisance actions. And the current law does to an extent, but when you look at the spectrum of right to farm laws across the country and the level of protection provided, including acknowledging that the agricultural activities need to change and evolve and diversify in order to survive, Vermont's law is one of the least protective of agricultural activities, because it does not provide a certain protection. It does allow neighboring property owners to effectively defeat the presumption against nuisance in multiple different ways. In discussions with other people, including extension services from other states, they have acknowledged that it is a weak protection. So yes, this bill is a stronger protection. Will it affect neighbors' property rights? It may, but that's a factual determination. It may.
And the new draft that we put together, does it encroach upon the neighbors more? Or are they, I mean, I think I heard you say they're still protected and allowed to,
Again, the purpose of these acts, these right to farm laws, is to protect a farmer from nuisance actions, and in many states, trespass actions from neighboring property owners. This bill does that. This draft does that. But it doesn't take away every legal opportunity that a neighboring property owner has to seek recourse. Again, they can seek a negligence claim, and again, they can challenge whether or not the farm meets the right to farm protection afforded. They can say that it's not a custom or practice, it's not a generally acceptable agricultural practice, that the farmer is violating pesticide rule, that the farmer is violating the required agricultural practices. That becomes factual. It does. But they have that opportunity. The courts have said when you have that opportunity, it doesn't necessarily remove your remedy. You still have a remedy. It's just you have different criteria that you need to meet in order to achieve your remedy.
questions from the committee yet? Steve, have you gone through 2.3 draft?
Good morning. Yes, I have, Senator.
And-
Steve Collier from the Agency of Agriculture.
And what is your determination, your thoughts in regards to 2.3?
Well,
The agency.
I plan on talking to Mr. O'Grady later today, actually, because I do have some thoughts about it. First, I think it's a great step forward. And I want to just comment a little bit about what Scott said. When I first walked in the room, I heard him say that this statute would require property owners to rely on the Agency of Agriculture and ANR to enforce the law. That's just not right. We have administrative enforcement authority. So my agency has the authority to enforce the RAPs. Whether we do that or not has zero impact on whether a neighbor can bring a nuisance action or a trespass action. So like linking those is a misnomer. We can either act or not act. ANR can either act or not act. That has zero bearing on a neighbor's right to bring a suit. Regardless of what we do, a neighbor can bring a nuisance or trespass action. And then to Mike's point, the whole point is about protecting farms. Right now, the way the statute is written, I was a litigator for most of my career, so I spent a lot of time in court trying to evaluate statutes and what the law means. When I read the current statute, I can't give good advice either to a farm or to a neighbor about what the outcome is. That's not a good law. Like when you have a law that leaves it so open to interpretation that nobody knows what's going to happen when you get in front of a court, that's a bad law. And that's what it is right now. You can look at that law, apply it to any situation, and you can't reasonably predict the outcome unless you're on one extreme or the other. And so it's not, to me, this doesn't limit any property owner's rights. It does define them. And that's a key difference. I mean, every person could still bring a nuisance or trespass action. What would change with this law is that the scope of that action would be better defined. And I think that's the question when you have these actions with, we're losing farms, we're gaining neighbors, if we want to gain neighbors. But when you have fewer and fewer people who are familiar with agricultural activities, you have fewer and fewer farms, and you have less land that's surrounded only by other farms, then you've got to decide, I think the legislature is, what do we want to do? Do we want to define what farmers are allowed to do? Or do we want to allow every individual citizen and every individual court to define that on a case-by-case basis? So if you think manure shouldn't stink, then you should legislate that. You should say, you know what, farms, manure can't stink. Then we're not gonna have any farms, or we're gonna need some sort of a solution that we don't currently have. But right now, a neighbor can file a nuisance action against a farm and prevail, as happened in the Erie Point case, for manure stinking. Well, manure stinks, and we required farms to actually store that manure and to not spread it in the winter and to not spread it when the soil is not appropriate, to be able to store it. And to do that, to store it, makes it stink more because you have to agitate it so that you can spread it. So the point I think we're saying is the state legislature should decide what farms can do and what they can't do. And that's why, like, having those rules in place and then telling farms and neighbors have a right to come to the legislature, farmers have a right to come to the legislature, but those policy decisions should be decided by the legislature, not by individual neighbors. And so if a farm is not complying with the law, then they're going to lose in court. If a farm is complying with the law, then hopefully they would win in court. In the mediation provision, it's a great idea. It doesn't change anything because you can't force people to agree. But requiring that attempt is really important because a lot of neighbors would rather go talk to their lawyer than go talk to their neighbor. So the idea that a neighbor has to first engage, that's a great idea because hopefully there's a solution. So, I mean, I have some other thoughts I want to talk to Mr. O'Grady about, but the core issue is this law as written doesn't help. I mean, it might help at the end of the game, but that's after 2 years of litigation. And if you want a good law, you allow people to make reasoned judgment about on the front end about whether a lawsuit's a good idea.
See, what puzzles me is we haven't had one citizen come to the committee and ask us, well, you've got to relax these rules. You know, we haven't had any complaints from neighbors. We've had complaints from farmers that it's not fair the way it is now. We've had, you folks in from the agency that feels that it needs updating to be more predictable. Michael, our legislative council person, has researched this to no end, trying to figure out if we were going beyond our bounds, you might say, and being tougher than any other state. And we want to try to be have it so it's predictable by both sides, and we certainly don't want to discriminate against the homeowner that's neighboring the farmer, and trying to be somewhere in the middle with other states on getting this passed and updated so that you don't spend 2 years fighting the thing one way or the other. Because what if the homeowner is a person with moderate means and not well-to-do? They aren't going to be able to afford to be in court for 2 years any more than the farmer can afford to be there for 2 years. And so we're just trying to be fair with this whole deal and have it so we can all enjoy our property and not have one overrunning the other. Yesterday, we had one farmer in that was complaining about his farmer neighbor. And so, you know, it makes it difficult to try to balance this out in a fair and equitable way. Brian?
That's for sure. Do we have, is there a way, this might be information we can't get, but is there a way to find out how many lawsuits we've had in this state over this for the past 20 years
I thought
that
we
something we
had a
can do?
report on that.
early on?
Mike,
It's really not possible to give you
Public sort of,
well, it's a certain response.
okay,
Because over the last 20 years, the reporting from the superior courts has gotten a lot better. But previous to like the last 5 years, 6 years, those superior court decisions were not publicly disseminated. And you had to contact the court, you had to know about
the case.
the case, and know about the decision, and contact the court to get a copy of it. And it wasn't electronic, it was like literally call, you know.
Right.
And so it's difficult to say for sure. The ones that are available electronically, I would say that there's about 5 that you can find, say on Westlaw. There's the Area Point case, there's Chicken versus Ox, Pig Farm case in Stowe. There's 2 to 3 Trigger versus Ox, Pig Farm, Area Point, and there's
Pesticide one.
yeah, the pesticide one.
Or any of them, do you know about smell? The smell keeps coming up.
Oh, Gary Point.
Area Point.
Area Point.
And it definitely came up in the Stowe.
In the
Pig
Stowe one.
Farm, but I don't think they decided on smell. I'd have to go back to that
Okay.
case.
So maybe 1. Okay, thank you.
yeah, so there hasn't been
The time.
that many.
Okay. Right,
And
whenever.
I think as we get fewer and fewer farms, there's less and less, because, you know, these farms nowadays have to follow the RAPs and the pesticide rules, and, I mean, they're under pretty, strict management. I know that, you know, especially the big farms are, you know, they're pretty careful. You know, they have professional people that work for them, usually spreading the pesticides and things. So for the most part, you know, this is really just an update of our old rules or our old law that, and there's very few laws that stay on the books for that long without being updated and taken care of in a proper form, which is here.
Right, so in my notes from an earlier testimony, somebody said that, and I don't know if it was you, Mr. Sanderson, or somebody else said that through this, we could be creating a culture of getting more big farms in and not helping, you know, smaller farms. Do you remember, Scott, if that was you or not? These were notes from a while ago that I'm just going through.
I think I made a point similar. Oh, I'm sorry. It looks okay. It looks like I'm in now. I think I made a point similar that in other states, what we've seen as right to farm laws have gotten significantly stronger is that they have sometimes been used by large industrial farms as a way to blunt neighboring small farmers and neighbors' claims for protection. And so most recently, North Carolina is a really good example of this, where a series of nuisance lawsuits against large hog farms, I believe they were under contract with Smithfield, the different farms, but I'm not 100% certain of that. But the legislature there responded to that by passing a right to farm law, despite a situation where, plaintiffs were able to find manure residue inside their homes and things like that. And so, that right to farm law, or that right to farm bill, was seemed very much motivated to provide what is an unbalanced protection in favor of these really big farms, rather than the neighbors who had actually been there for quite a long time.
That's all, thanks.
Brian?
Thank you, Mr. Chair. So maybe I could ask each of the three attorneys this question. Does 2.3, the draft, contain fewer factual determination circumstances than current law? That's my first question. And the second one is, by reducing the number of factual determinations, does that make the likelihood of clarity, for lack of a better term? In other words, Steve, you made a good point about, you don't really know how things are going to go if it's not pretty clear about what the law says is proper and isn't. And so I'm getting the idea that the draft that we have now has reduced factual determination to some degree, which I think is good, because I think it provides more clarity. Does that make any sense at all?
You want me to go for it?
All three, but five.
It absolutely has fewer factual questions. However, as both Mr. O'Grady and Mr. Anderson testified, that new provision about customary practices opens the door to a whole lot of factual questions. And I understood that you did that to create more balance, so that neighbors would have more ability, that the REPs would not be dispositive, pesticide rules would not be dispositive. So I think that you added that provision to give neighbors more rights, and I wouldn't say rights, but it does give neighbors more opportunity to contest, but it also creates a lot of factual questions. Because, so one theory, and I haven't yet discussed this with Mike, I did a while ago, but one way to address that, I think, is that right now, I think the way that you have to protect the REP standard and customary practices laid out is they're probably an affirmative defense, which means the farmer has to prove it. In a normal lawsuit, plaintiff has to prove every element to prevail. And I think you could mitigate the factual questions a little bit if you wanted to, by making it clear that the plaintiff has to prove that a farmer is creating a nuisance, including that a farmer is not following the REPs or is not following customary practices. And what that does is it makes the plaintiff come up with facts to prove the case. And if they can't, then the farm doesn't have to do as much work to defend itself. If the plaintiff can come up with the facts to prove that they're not using good practices, then the farm's gonna have to defend itself. But that makes sense if there are at least facts to prove it. And what the facts means is also experts. And so that's just a lot of cost. If you're gonna talk about what's customary and what's normal, and so then suddenly it opens the door to, okay, well, who can define that? Experts. And so then you have to bring in an expert, or you don't have to, but if you don't, you're very vulnerable. So you could probably balance that desire to expand the nuisance protection by also making it clear that if the plaintiffs are going to bring a nuisance action, they have to prove the farmer's doing it wrong.
Good answer, thank you.
You sure?
Michael?
Well, I definitely think there are fewer factual determinations in the current draft. In the current law, you have to show that the activity is conducted in conformity with federal, state, and local laws and regulations. Frankly, I don't even know why local laws and regulations are in there, because farms are exempt from local law and regulation. You have to show it is consistent with a good agricultural practice, which has never really been defined. So you could argue that defining what a generally accepted agricultural practice is just defining what a good agricultural practice is underneath the current law. You also have to show that it was established prior to surrounding non-agricultural activities. You also have to show that it's not significantly changed since the commencement of the prior surrounding non-agricultural activity. Those are all factual. In addition, the plaintiff then can say that the activity has a substantial adverse effect on health, safety, or welfare, which is a factual determination, or has a noxious and significant interference with the use and enjoyment of the neighboring property. Again, a factual determination. In contrast, the draft that you have in front of you, 2.3, they've been in operation for more than 1 year, not a nuisance or trespass at the time of the activity, is conducted in accordance with generally accepted agricultural practices. Conformance with the RAPs and your MFO or LFO permit, conformance with the pesticide rules, and conformance with generally the practices conducted consistent with custom and standards, which is arguably already a requirement of the right to farm law. So there's fewer factual determinations, but it doesn't eliminate all of them.
Another good answer.
Scott, would you like to comment on Brian's question?
Sure, absolutely. So, I think it's helpful to look at it in the context of the overall law and the overall nuisance or trespass claim. And so, if we look at specifically at how a farm is going to gain the protection of the right to farm law under the current right to farm law versus this bill, I think it's a similar number of factual determinations, right? Attorney O'Grady just compared conducted in conformity with federal, state, and local laws, right? That's under the current right to farm law. The comparable part of the right to farm bill is the pesticides regulations, the water quality regulations. So I think those are comparable. Then under the current law, it's consistent with good agricultural practices. To me, that strikes me as comparable to the establishing industry custom component of generally accepted agricultural practices under the current law or under the draft bill. And then if we go down to the established prior to surrounding non-agricultural activities and hasn't significantly changed, that's sort of the coming to the nuisance component of the current law. And I think that's comparable to the activity has been in operation for 1 year or more at the time that the lawsuit is instituted. So I think if we're looking at how a farmer goes about getting the various protections, I think there's a similar number of factual determinations. Of course, there's an additional one in the new bill for mediation requirement, right? You have to bring evidence to show that that mediation requirement has or has not been satisfied. That's likely a much easier, or I would assume that would be an easier factual determination, but I'm not 100% sure about that. Now to Attorney Collier's point, I think about the affirmative defense and where the burden lies here. I think it's useful to note that one of the reasons that the current right to farm law has more factual determination surrounding that qualification is because it's trying to institute a very fair and balanced process. So, absent any right to farm law, a neighbor is still going to have to bring evidence that a farmer's activity is causing an unreasonable and substantial interference with their use and enjoyment of property, right? And only then, once a neighbor is able to show that, is there anything for a farmer to show under the current law? And that doesn't seem to change between the two different drafts. So then we go into those equal factual determinations where I think it's about the same amount. And then after that, we ask, okay, under current law versus the bill, what happens? Under current law, the neighbor has a chance to say, okay, well, actually, this harm is extremely severe, notwithstanding these other protections, I still need a little bit of help here. That option is different under the current law. Instead of being able to show that that harm is severe under in the way that sort of conforms with nuisance and trespasses purpose, which is to protect harm or prevent harm, it shifts over to negligence, like Attorney O'Grady discussed. So we look at those processes. I think there may be an extra factual determination or two under the current law, but I think it's because of the current law's determination to keep things balanced and to preserve that option of last resort for landowners.
Yeah, thank you, Scott. Any further comments or questions from the committee? If not, we've got some farmers that would like to testify, but you guys are gonna hang with us, right? And, so Kylie Chittenden, would you like to testify in regards to our draft bill?
Sure. Can you hear me?
Yes.
Okay. Yeah, I just wrote some notes that I thought I would share. It'll seem a little similar to our last discussion, but I just want to make sure it's clear that the majority of us are really trying to be great neighbors, and this bill recognizes that, this draft anyways. It gives consistency and expectations that are clarified in this draft versus the current law. And I think it provides protection for farmers and allows a solution before war is waged. It gives us a chance to pump the brakes and avoid litigation. Farmers are only 1% to 2% of our population, and it is tricky. Our voice is often lost. This update will give our neighbors our neighborhoods, I should say, guideposts to follow with a solution through mediation. It also recognized the importance of agriculture in our state to the economy, and I really support that. I think our state can move the needle on a modernized right to farm law. We just heard that our current law is 25 years old. It's a little antiquated. It doesn't recognize how agriculture has changed in our state. And our margins are tight. Looking for ways to prevent litigation is really necessary for agriculture to continue. We're not prepared for these sort of lawsuits in our industry. And truthfully, in a time right now where it's easy to type behind a screen and hard to meet with someone face to face, that's the old-fashioned way to solve problems, is to have a face-to-face discussion. And I think this mediation will avoid a lot of concerns through giving the farmers a chance for education and neighbors to share their side without going to litigation. So I really feel like we're on the right track with this.
Yeah. Thank you, Kylie. Are there questions for Kylie? Oh, no. And Kylie, how close do you have homeowners near your farm that aren't associated with the farm?
I mean, on all boundaries of our farm, we have neighbors that are not associated. Our farm is in 4 different towns, so we have neighbors in each of those towns that are not related to our farm.
Yeah. Any problems with the neighbors over the years, or?
If there's ever problems with neighbors, I mean, we've never had a right, we've never been sued by a neighbor or anything like that, but we also are careful to try and educate if there's questions about what we're doing, when we're made aware of it. So I think as more neighbors move in, there's less and less of those families that have been here for generations as neighbors. A lot of our neighbors also hunt on our grounds, so that gives us sometimes a chance to see someone face to face. But I don't know, just giving us a chance to talk to our neighbor before litigation is really important.
Did you, I think you told us that you do a little newsletter to your communities around you and get word out to them for different things that are happening on the farm?
I don't do the newsletter, but we have had neighborhood parties. Like last fall, we invited all of our neighbors to our shop. We had live music and food that just to, at the end of harvest, just to thank them, because there are times where just normal practices of farming, the neighbors are aware of what we're doing. Our tractors are out. So we also have a 4-H club. So a lot of the neighboring kids are at our farm after school a couple days a week. So I think as our farms are evolving, we're finding ways to connect with neighbors in ways that we haven't before. But again, there's fewer of us all the time to get the message out about where your food comes from. So it's a big job that we have to remain relevant in our neighborhoods.
Yeah. Brian?
Yeah, thank you, Mr. Chair. Kylie, you bring up a great point. Laura DePietro from the agency yesterday made a remark which resonated with me. She apparently has initiated talks and discussions face to face between parties that might not have been getting along too well. And she said, one of the funny things is when people get behind the screen and get online, they don't have to sort of engage with each other. And she used the example of throwing a baseball so that she could hit both structures where people live. And they had never met each other. They had never actually sat down together at a table. And she said once they did, the thing got solved in, I don't know, half an hour or something. It didn't take long. And I thought that was a really good idea. And I think that's why we're all in favor of this mediation provision in the bill. So.
Yeah.
I'd just like to add to that. I think most people try to avoid conflict. And I think that if you can create, I actually personally think the most important thing about the bill is the mediation creates an avenue for neighbors to talk to each other. If we had some testimony that, well, people just talk to it, they don't.
Or if they do, it's online or.
You know, I see in the Front Porch Forum in my community all the time, people post stuff and start off on the wrong foot.
Yeah.
And I think the more we can create conversation, our society is becoming more litigious.
Yeah.
And I don't think that's totally healthy for us.
I agree.
Yes. Any other questions for Kylie? If not, thank you, Kylie, for your time. We certainly appreciate it.
Thank you.
Bill, I think I have Bill Rowell. Are you with us, Bill?
I am with you.
Well, that's
Let me
good
get,
that you're still with us, because you're there you go. Now we can see you.
Right on.
Did you had an opportunity, Bill, to look over the third draft?
I've looked them over enough. I'm still recalling last year when we had the gentleman from Arkansas, University of Arkansas, the National Right to Farm Ag Law Center on to testify. And I remember what he said about our farm bill, our right to farm. He said, Vermont's right to farm law makes quite an impression. And I thought, why would we change it? He said, let me finish. It's not a favorable impression. It doesn't do anything for you. Now, how do we have innovative and thriving farms with no protection? I mean, everybody needs some protection. The neighbors need protection. The farmers need some protection. There's supposed to be some sense of balance here. And the thing that gets me is this. You folks went to great odds to establish the required agricultural practices. And turns out they work pretty good. Turns out we've made some real gains with agriculture by following the required ag practices. And every year we have to show that we're fit to stay in compliance and get renewed. I don't know, generally accepted ag practices are just that. They're generally accepted. If you're not following the RAPs and staying in compliance, then you're not following a generally accepted practice. It's about that simple. I don't know. I thought Mr. Collier addressed that situation in a good light, in the proper context. It made sense. And, you know, we went from 648,000 farms in this country in 1970, and we're down to 29,000 left. And of the 29,000 left, they produced 526.8 billion pounds of milk ending 2022. A little over half of that milk was produced by 3% of the farms. So, you know, I keep hearing this talk about industrial farms. They still have to follow the practices if they want their certificate renewed. And if 3% of them are feeding half the country or producing half of the product, how do you criticize them and sit down at the table and eat dinner? I mean, if you don't want farms, you don't want farms. Maybe Connecticut's a good place to move. They don't have a lot of farms. Vermont was always an agricultural region. We move along at a different pace than a lot of other parts of the country. I get that. But we have a lot of neighbors coming in. Hey, they're welcome. It's a free country. But if they don't understand the practices and we have nothing to protect ourselves with, there's not a lot of incentive there for future generations. And if that's the case, then maybe you want to think about takeout from another state or another country, because nobody can produce food unless they have some incentive and some support. And I think Vermont does pretty good with both, but we need to improve things a little bit so that the farmer at least has a chance to move forward instead of always being a target. Now, you know, I read the testimony that the gentleman, the engineer from Cabot had posted, and his neighbor doesn't sound like anybody that goes to my church. I don't know where you come up with a neighbor like that, but I don't envy him for it.
Well,
I don't
don't wish
know.
too hard, you may get one.
Well, we may have some, but you know, there's a way to approach people too. And being vindictive isn't a good way to approach anybody. We all need an opportunity to live a good life, don't we? We all need an opportunity to make a good living. So I guess the generally accepted ag practices, for me, that sounds like a good statement, generally accepted agricultural practices. And if you're not upholding the RAPs, then you don't have a generally accepted practice, do you? Because if it's generally accepted, it has to be in compliance with the required ag practices. It says in that by itself that you're following the intent of the law established by the legislative body to practice your profession as intended. Well, what's so hard to understand about that? I mean, I guess I may be a little slow, but I think sometimes too much gets read into things and it sets us back quite a lot. I don't think that you need to change the revised draft, much of any. There may be a word or two you could tinker with, but for Pete's sake, give us something.
Yeah.
Simple as that.
Yeah, so you're generally satisfied with what we have at the present. So any questions for Bill from committee members?
Well, I have one other thing I'd like to say. If the gentleman is too small to be regulated as a farm, what do you call him? Is it a farm? What are we regulating here?
Well, it would fall on the community under their public health laws, but as you read the letter and was reported to us, he had 10 animals at his place of where he lived. And by the time the ag agency got there to check him out, he was down to 3. So he was under was not under the definition of farming because he had too few animals. But then it was reported to us that he used to be a cattle dealer when he lived on the house that the engineer bought. So it made me believe if he went from 10 animals to 3 animals, that possibly he's still dealing, he's a cattle dealer. So I know the agency was going to check it out and see if he had a cattle dealer's license. And if he does have, well, then he would fall under the rules and regs that we put forth, and it might help the neighbor where he spread the manure right along the fence line. So, you know, that was not a very good story, and I don't think any of us want to have neighbors like the engineer had, but
No.
so anyways, I want to still get Amanda on. Morning, Amanda.
Morning, thank you. Well, I appreciate the testimony this morning, and certainly I'm not going to go back into the full testimony we gave the other day, but I'm here really on behalf of the Vermont Dairy Producers Alliance, and I just wanted to reiterate a couple things and just point out, I guess, based on the conversation where you ended it with Bill, is unfortunately or fortunately, we have neighbors, whether we're farming or not, that just don't get along. And this happens in every state, in every county, probably in every town. And I'm not sure that the right to farm is meant to be used in every situation. Very specifically, we have a agricultural sector industry, vibrant, it's diversifying, it's innovative, and I'm very proud of our ag sector, and I'm speaking for the dairy sector. Pretty proud. I'm pretty proud to be part of that group. And just for instance, we had a neighbor farm who had a barn fire last night. It's always on the coldest day in the winter. No cows were lost, thank goodness. But, you know, we've got farmers stepping in to help farmers and relocating cattle, and neighbors bringing food and hot coffee to the volunteer fire department, which is made up of farmers or retired farmers or people who grew up on a farm. So pretty proud of that. And I guess for me this morning, what the right to farm means in this draft is simply basic updating of an industry that has developed vastly in the last 25 years. And I think, you know, we all do the best we know how to do, but we're creative, we're innovators, we create inventions, technologies. We are practicing regenerative soil practices, which somebody next door might not like it because guess what? There's weeds and they don't like looking at weeds. We might be trying out a different type of seed. You know, there's just all these things that progressive dairy farming, sustainable dairy farming does. And agriculture, it could be berries, it could be Christmas trees, like I said in my earlier testimony a couple days ago. So I guess just closing, I want to thank the committee for their hard work and Ledge Council Michael O'Grady for spending not just this session, but really years on this. And this was, you know, in process and thought about for probably 4 or 5 years now. And we've been very sensitive to trying to create a process where it allows a reasonable way of solving issues. And earlier people have testified on that. The mediation piece, I think, is huge. I appreciated the Ag Agency testimony this morning as well. I think they brought up a lot of good points. And I guess I just asked the committee in closing to just think about what our Vermonters have done, not just farmers, in the investment into agriculture, and whether or not we deserve an updated right to farm or not. And that's basically it. That's basically what we're asking for. That's basically, I think, what you guys have come up with. And I guess I'm just going to leave it there. I just think we are as a sector deserving of this. Thank you.
Yeah. Thank you, Amanda. Questions for Amanda? No? Polly, everybody is happy, I guess. I'm not gonna ask you how many neighbors you've got around your farm, because you know, it would be hard to count them all probably. But have you, have you had any problems with your neighbors? And I know I haven't read anything in any court news, so over the years, though, with the amount of land that you folks have, you must have run into some snags with neighbors, and how'd you deal with them if you did have run into issues?
So we are the ones that do the newsletters and do the outreach.
Okay.
Yeah, and we do active on social media, but you know, prior to that, we've had a few neighbors that would not approach us directly. And so oftentimes, unfortunately, the agency had to step in and mediate, which, you know, it's unfortunate. I think it would be much better to have that discussion in person, face to face. But overall, no, we cultivate, we appreciate our neighbors, and I feel like the neighbors appreciate us. And I think Kylie had said, you know, when there's a snowstorm and they need plowing or they go off the road. But more importantly, I think we just try to explain our farming operation. And somebody else also mentioned something about smell. I'm not sure which, it's hard to see on Zoom who talks when, but you know, a lot of the smell, again, as Steve said, is we have to build these manure storage facilities, which gathers the manure, right? And so then we're doing what is best by injecting that manure right into the soils. And so you can't have one without the other. Certainly having the digesters takes out some of the smell, but I think, you know, just explaining to people who are moving into the area, like, you know, we are a farm, we've been here X amount of years, this is what we do, will help. This is not meant to create more issues. It's really to just give a little bit of backstop. So if there is a disagreement, there's a process, and it allows for innovation on our farms because we do change.
Thank you, Amanda. So are there, I think we've gotten through, Tucker couldn't make it this morning. Tucker ran into some problems on the farm this morning, so he isn't going to be able to be with us. So are there any other questions by committee members? All set, Irene? Yeah.
I'm set. Thank you. Appreciate all the testimony.
Yeah, so if there no other, anything else from Michael or no?
No.
Stephen?
No, thank you.
Well, I want to thank all of our guests, for being with us this morning, and, Bill and Amanda and on Zoom, Scott on Zoom. So we'll keep talking over what we heard this morning and, try to come to some conclusion, in the near future. So, I think Linda will adjourn this portion. We have the organic buyers, the two companies that buy
So,
milk, organic milk in the state, up next at 10:45. So we've got a few minutes, if we need to take a little break.
thank you.
So we'll